Hello everyone. This presentation and the next one will explain about the remedies available for a tortious act. We have seen that when the defendant infringes or violates the right of the plaintiff, he can sue the defendant for the remedy provided by law. We have also seen that the law of torts is founded on the principle that every injury must have a remedy, ubi jus, ibi remedium. Remedy is the means by which the plaintiff whose right is violated by the defendant is compensated. Remedies are classified under two heads: legal remedies and extra legal remedies. Legal remedies are remedies provided by law, and extra legal remedies are remedies exercised by the party who suffered the violation of his right. Legal remedies include damages, injunction, specific restitution of property, and remedies provided under the Constitution and other laws. Extrajudicial or extra legal remedies include self-help, expulsion of trespasser, re-entry on land, recapture of goods, distress damage feasant, and abatement of nuisance. Damages is the pecuniary compensation awarded to the plaintiff for violation of his right, payable by the defendant who is responsible for the violation or breach of duty. Damages may be general damages or special damages. General damages are awarded for compensating the loss that is presumed to flow from the breach of duty. Special damages are awarded to compensate any particular loss which cannot be presumed in the natural course of things but is peculiar to the case. For example, if B is injured by A because of his negligence, B is hospitalized and undergoes treatment for 10 days. Here, the cost of the treatment during hospitalization, loss caused due to inconvenience suffered, and the loss of employment during that period may be in the form of deduction of salary or leave, naturally flow from the act and can be presumed. But where B completes 24 years and he had to appear for an interview which was the last opportunity for getting a regular employment, the damage suffered by B is special to his case, and here special damages can be awarded, but this has to be specially claimed and proved by B. Damages awarded may be punitive or exemplary when it is not intended to compensate the plaintiff but to punish the defendant for outrageous nature of the act, and where the motive and conduct of the defendant is despicable. Malicious prosecution initiated to vex the individual out of vengeance or hatred can be a case where exemplary damages can be awarded. The plaintiff has always to prove that the loss caused to him or injury suffered by him was because of the wrongful act of the defendant and not due to any other extraneous factor. Damages is the quantum of money claimed or paid to compensate the loss suffered by the plaintiff. The object of awarding damages is to place the plaintiff in the position in which he would have been had the defendant not infringed his right. The principle of assessment of damages is restitutio in integrum, that is, complete reparation. The court attempts to assess and grant a fair and reasonable compensation. It may not be perfect compensation. Damages awarded may be nominal, substantial, or contemptuous. In nominal damages, a small sum of money is awarded as damages as a token of recognition of the fact that the plaintiff's right has been infringed and that no noticeable loss has been proved. Here, there may be no damage caused, but there is injury to plaintiff's right, which has to be proved by the plaintiff. Substantial damages are awarded when the plaintiff suffers actual loss and it is compensatory because it is intended to fairly and reasonably compensate the loss suffered by the plaintiff. Contemptuous damages express contempt and disapproval of the plaintiff's conduct in approaching the court. Here the plaintiff may prove his case, but the court feels that the plaintiff should not have approached the court in the matter. Here the object of this suit is not recognition of his right but compensation. For example, where a rich man finds a child who was stranded in an exhibition and crying for his parents. He picks up the child, brings him to house and feeds him for a couple of days. The parents of the child, who were farm laborers, and who came to know that the child was with A approach A and take back their child. Subsequently, A files a suit against the parents stating that because of their negligence to take care of the child, he had been put to inconvenience of taking the child to house and taking care of it till the parents returned, that is for about a month. He claimed compensation for the inconvenience caused to him and for the money and effort he had put in to maintain the child for nearly a month. Here, the damages the court would award would be contemptuous damages. Now, remoteness of damage. What is it about? Suppose A throws a lighted squib negligently on a busy public road from a terrace. B is hit by it, who catches it and throws it away, which hits C, which in turn is thrown away by C, and it hits D, who in turn pushes it on to E, and it goes on till the squib is finally put off. Here, by the negligent act of A, B, C, D, E, and a number of others are injured. Can A be held liable for all these consequences? Law says that defendant's liability should be limited, or else it would ruin him. No person is responsible ad infinitum, that is endlessly, for the consequences of his act. The law will not permit to recover for all direct consequences of the tort. In jure non remota causa sed proxima spectator. In law, the immediate or proximate cause and not the remote cause is taken into consideration. When will the damage be considered to be remote? A person is responsible for the natural and probable consequences of his act, and it is not necessary that such consequences should have been foreseen by a reasonable man. The rules pertaining to remoteness of damage are: 1. When the consequences suffered by the plaintiff from the defendant are wholly unlikely consequences, the consequences are said to be remote. 2. When the act of the defendant brings about certain immediate consequences, which in turn brings about a chain of further consequences, the liability would be only for immediate consequences. For example, where A due to negligence hits B, who suffers injury and is hospitalized. While being treated for the injury, it was found that he had enlarged spleen. Because of this, he was ill for a long period and spent a lot of money on medicines and treatment. Here, A will be liable only for the injury caused and has to compensate only to the extent of the cost for treating the injury. Rupture of spleen and consequential loss suffered are unlikely consequences and are remote in this case. Similarly, A, while going to his workplace, was hit by B's vehicle because of his negligent driving. A suffers serious injuries and is hospitalized. While undergoing treatment, it is found that gangrene set in and his leg had to be amputated to save his life. He was about to marry a girl in a fortnight from the date of accident. Because of the accident, the engagement was cancelled. As he was working in army, when his leg was amputated, he was discharged from service. He paid advance to a builder for purchasing a flat. Because of the situation after the accident, he could not complete the formalities and hence he lost the advance paid as well as the flat. Now, will B be liable for all these consequences as they were all triggered by the accident? The law says that the defendant can be held liable only for the immediate consequences and not for the chain of consequences that followed the act. Here, compensation can be paid for the injury caused and for the loss suffered due to injury and expenses incurred for treatment. The nature of the injury was such that a reasonable man may not be able to foresee all the other consequences that actually occur. Thus, in the problem of remoteness, the cause and effect relationship between the defendant's act and plaintiff's injury has to be established. The factors that are important to justify the imposition of liability has to be selected and a boundary line of consequences has to be drawn beyond which the defendant will not be liable. So many facts in the above example may not be known to the defendant, like the plaintiff was a diabetic, he was in army, he was engaged to marry a girl, he had paid advance to buy property, etc. And in such circumstances, he cannot be liable for the chain of consequences that followed the immediate consequence, that is injury and hospitalization for treatment of the injury. When the consequences are intended, they are direct and immediate. The man is presumed to intend the natural and probable consequences of his act, and natural and probable consequences are those that could be foreseen by a man of ordinary prudence. Some consequences may not be natural or probable, but can be directly traced to the defendant's act. A man is expected to anticipate and guard against all reasonably foreseeable consequences and not against those which could not be foreseen to occur by a reasonable man. The following are considered to be remote consequences: where the plaintiff was responsible for the injury suffered by him, where the real or direct cause for the damage suffered by the plaintiff is not the act of the defendant but some extraneous cause not traceable, where the damage caused to the plaintiff is due to the act of a person bound by law to decide the matter judicially or independently, where the chain of cause and effect is broken by an independent third party which could not be anticipated, the damage caused by such intervention is too remote. Where A, for example, is threatening B with a knife to vacate the premises. C all of a sudden falls on A, who falls on B, and knife strikes B, causing injury. Here, A will be liable only for assault and not for battery because the injury was due to intervening act of C, not expected by A. Where a new act intervenes, if the thing likely to happen could be anticipated by the wrongdoer, he would be liable. But where the defendant compels a third party to act which produces damage, the defendant would be liable. For example, A throws a lighted torch on B's property and C, in order to prevent the property from catching fire, picks it up and throws it away, which accidentally falls on B, who was entering into the property, and B was injured. Here, A would be liable because C was forced to act, which by accident resulted in damage to B. Children's acts do not constitute intervening acts because one who provides opportunity to the child to act in a mischievous manner, causing damage, is deemed to have foreseen it and hence he would be liable for it. To find out whether a consequence is connected with the wrong so as to impose liability, there are two theories. First theory is direct consequence theory, advocated in Re Polymis case. Here, the servants of the defendant's company, while unloading the cargo of a ship, drop a plank, and this creates a spark, and as oil was spilt on the floor of the ship, the spark ignites it and the ship catches fire and is destroyed. The plaintiffs, the ship owners, sue the defendant company for the loss suffered due to the negligent acts of the servant of the company. Here, the defendants plead that a man of ordinary prudence cannot foresee that a fall of a plank would ignite a spark and the spilt oil in the ship would catch fire and destroy the ship. However, the court held that the defendants were liable because the loss suffered by the plaintiff was the direct consequence of the negligent act of the defendant's servants. Hence, according to first theory, if the damage caused to the plaintiff is the direct consequence of the defendant's negligence, he would be liable even where the consequence was one which could not be reasonably foreseen. This rule was disapproved and declared bad law in Wagonmount's case, which advocated the second theory, that is the foreseeability theory. In this case, the defendant's servants caused oil to leak from the ship into the harbor. The plaintiffs owned a wharf where ships were repaired. The oil that leaked on water surface drifted to the wharf where work was going on. A supervisor of plaintiff's wharf inquired if the oil that leaked could catch fire, and he was assured that it would not. However, a spark from the welding and the debris mixed with spilt oil caught fire and destroyed the wharf. The plaintiffs sued the oil tank ship, the defendants, which caused the spill for damages for the loss suffered. The court held that the plaintiffs were not entitled to damages because the damage caused was not foreseeable by a reasonable man, that is, a man of ordinary prudence, and hence it is removed. Thus, according to the second theory, the test of liability would be the foreseeability of the damage by a reasonable man and not the direct consequence test, that is, the defendant's act was the direct cause of the damage suffered. The next question would be, how should damages to be awarded be measured? Measure of damages is about deciding the amount of money that has to be paid by the defendant to the plaintiff to compensate the loss suffered due to defendant's breach of duty. The principle that guides the measure of damages is that the blameworthy must compensate the blameless based on the injury suffered so that it is repaired. The assessment of damages are made under two heads. General damages to compensate for consequence that naturally and normally flow from wrongful act, and this does not require specific pleadings and proof. And special damages to compensate for special loss which do not naturally flow from defendant's wrongful act but should be specifically pleaded and proved by the plaintiff as a consequence of defendant's wrongful act. Special damage includes actual damage because of special circumstances and the particular damage exclusively suffered by the plaintiff, and these have to be alleged and proved by the plaintiff. Prospective damages are damages which may arise in future in case of continuing damage by continuing torts like trespass, nuisance, etc., which accrue from day to day. Personal injury cases arise out of motor accidents and other injuries, and damages in such cases are awarded under different heads like damages for medical expenses, loss of enjoyment of life, loss of expectancy of life, inability to participate in various activities, diminished prospects of marriage, damage for loss of service consortium, etc., based on the facts and circumstances of each case. While granting compensation in accident cases, damages are granted or awarded under two heads. Pecuniary damages for the loss actually incurred and can be assessed in terms of money, and non-pecuniary damages where the loss suffered is beyond arithmetical calculation, where compensation is awarded for pain and suffering and loss of comfort in life. The special circumstances of the claimant, including his age, the deprivation suffered, and the effect of it on his future life, have to be taken into consideration. This, in brief, is about the various rules that govern award of damages as a remedy for tort. The remaining remedies will be dealt with in the last presentation in this series. Thank you.